been handed to in the courts where I sit, and in my that is my biggest drive. That is what makes me wake up and go to court. That I want to be fair, I want to be just, I want to satisfy those who come before me, even when they lose their cases. And I want to be fair to the parties and to my country also, and to myself. So I think I am driven by a great desire to be just and to do justice to others.
Thank you, my Lord. Now, we've discussed at length competence and suitability in the context of Article 73. And you have sought to persuade us that you're a man of integrity, you're a man who is competent and suitable. I'm sorry to have to ask you this again, my Lord. You're familiar with the Honorable Lady Justice Ruth Ginsburg of the United States. And her ladyship stood out as a champion of human rights. She stood out for gender equality, the rights of workers, and the separation of church and state. Those were basically her hallmark. Now you are seeking to become a member of the highest court in this country, which would then mean that you have reached the pinnacle of your judicial career, the crescendo. I want to understand your lordship. What unique attributes in terms of judicial philosophy are you going to bring to that court? And we're not talking here, you've got a very experienced career in various facets. You've demonstrated that. What in that career makes you unique to make a special contribution to this country as a member of the Supreme Court?
Thank you, Mr. Attorney General. You're right, I gave a very long story of myself when I came before you last time. I gave you a little bit of history of that contribution I made in my youth. I have given you some of my writings here, like for example, the Queer case here, groundbreaking in discrimination, and actually published by ILO, and has cost me invitations in places to as a groundbreaking jurisprudence in discrimination against women on grounds and men on grounds of HIV and AIDS. I have been very consistent on matters human rights, and I speak through my judgments. I have been very consistent in matters decent work and gender. I have been very consistent in in my leadership, because I've been lucky to be offered leadership positions right from my university days to be a leader outside Kenya and in the court, where I have demonstrated my ability to be a leader among leaders and to give direction, both legal, judicial, and administrative, whenever I'm given opportunity to do that. Judges speak mainly through their judgments, and I think I am a stickler of rule of law, justice, human rights, equality, and I think that rich experience I have I will be able to infuse and make contribution immensely in our collegial court, which has got very, very able judges and very well supported in terms of staff and research, unlike the superior courts, where we literally, most of the times, you're just on your own and doing so many cases. So our apex court is very well adored in terms of giving opportunity to those who are able and willing to make a positive contribution to good governance. Because you look at my judgments, especially to do with county governments, where corruption is involved, where due process has not been followed, and there are many decisions I can quote, especially to do with county governments, where my philosophy has come out as a stickler of human rights, justice, fairness, and good governance, as it were.
I am most obliged, my Lord, for answering those questions. That will be all from me, Chair.
Thank you, the Attorney General. Now is a chance for Commissioner Gishohi to continue the questions. Commissioner Gishohi.
Thank you, Chair. Judge, good morning.
Good morning.
Good. Take your water.
Thank you.
I want us to have a discussion in your role now as a state officer. And I'm sure you are aware that as a judge of the Supreme Court, even as a judge where you are a state officer. And I want us to focus to Article 232(1) of the Constitution on values and principles of public service. I would wish you to select two of those principles or values of public service and share with the Commission how you will be able to promote those values in the Supreme Court, at individual level, and also as a court. Two of those values.
This accountability.
Accountability, yes.
And well, I know transparency is also put separately, but they go together. But I really value those two, being very transparent and accountable through your the judgments you make, through the productivity as a person, being focused and productive, and giving a fair share of not taking advantage of a college.
Okay.
You know, there's a lot of that when you have teams work together. There are those who would want to shortchange others. I'm an equal player, and therefore I am transparent. I am accountable every time in whatever I do. And I am patriotic too, very patriotic. I love my country.
Good, Judge. Let's narrow those to two issues: accountability and efficiency and productivity in public service. The question is addressing accountability. How you are going to promote that as a judge, as a state officer, then move on to promotion of efficiency. And I've seen from the records here, you did a lot in 2016 in your own court, how you're going to promote efficiency and productivity within your court.
First of all, I support a lot the measurement of every work in terms of setting targets.
Very good.
And being able to be measured against those targets on a continuous basis. So that is key, and that involves planning. So I'm going to make a very good contribution to my leaders at the Supreme Court if I go there, in terms of organizational planning, setting smart targets, and also participating in achieving those targets.
So in case you have your mid-term review of those targets, what issues will you be looking for, or what do you look for?
Especially productivity for each judge, clearance of cases, timely judgments written. Also, I think now we are moving towards qualitative measurement, which I do support. I think we've just filled some questionnaires in that regard, and I'm happy we are also moving in that direction, because we had now people now wanting to do too much at the expense of quality. So I would support qualitative measurement also at that level.
Looking at the strategic plan for the Supreme Court, I had a chance to look at it last night, and I looked at the mission statement. And if I may, I can quote for you the mission statement, and I quote, facilitate social, economic, and political growth in Kenya. That's a quote from the mission statement of the Supreme Court. I want you to focus on how, when they say facilitate socio-economic, I want us to look at economic growth in Kenya. What is the role of judiciary in the promotion of our economic growth? In your view, what will be the role of the judiciary?
Yeah, and in particular the Supreme Court, especially dealing with the presidential disputes, election disputes, in a timely and just manner, to avoid matters which might be disruptive to our economy, in giving proper advisory opinions as and when called upon to do so by the national government, the county governments, so that you can give proper direction to our nation, to our country, to come up with good policies to enhance economic development.
Let's come to the ground. I'm sure you have heard about the 4 key agendas that the government is driving in terms of the midterm programs. Would you share with us those 4 key agendas, and how you can pick one of it and tell us how judiciary can promote the realization of that goal? Therefore,
development of infrastructure all over the country, key. Judiciary plays a key role there in bringing certainty of the law, making decisions which are certain and consistent, and in a timely manner, especially when it comes to procurement, because that is a key area which stifles development of infrastructure. In terms of health to all, we have a key role in interpreting the Constitution, especially on the socio-economic rights.
Okay, 3.
And we have the issue of education for
The 4 key agendas you've given us 2. I'm waiting for 2 more.
4 key agendas. That is health, infrastructure, and the other one is housing for all, for to the largest number of people.
Mm-hmm. Affordable housing?
Yes, affordable housing.
Mm-hmm.
And I think judiciary has a role in that respect, especially on these are matters under Article 43 of the Constitution. And I think the way we develop that law will play a key role in how, especially we deal with the vulnerable, those without housing, those occupying public land without title, and so on.
What about in terms of investors? Do you have any role in terms of investors in solving the disputes?
As key to investors most of the times is for them to be certain that with the law, that the law in the country is, they understand it well, and they know when they bring their capital that it will be safe.
Okay.
And that when they have disputes, they will be dealt with in a timely manner.
The last one? Those are 3.
And the last one is sometimes these things get elusive.
Okay, we get it. Okay, thank you, Shah. Just one more question, Honorable Judge.
Yeah.
I was also looking at that strategic plan of the Supreme Court, and I was looking at the stakeholders analysis in that report. And in that stakeholders analysis, members of staff are key stakeholders. The expectations from the court is a conducive working environment and facilitate professional career growth. If you go to those courts, you have the staff. Those are some of the expectations they have. How do you intend to mitigate or to meet those expectations? 2 ways we'll be able to do to meet those expectations of the staff. And that is included in this report for 2020-2022 or so.
First of all, as a judge of a Supreme Court, you are a leader where you are as a judge, and you work with people and with teams of people. And in terms of conducive environment, first of all, is yourself giving them respect and recognition.
Respect.
Appreciating the work they do. Finding ways of motivating them and inspiring them to achieve within the group as a Supreme Court, and by coming up with policies which motivate the employees in terms of promotion, in terms of resolution of any sort of dispute, because the issues arise all the time. So whatever. So as a leader in that court, you must engender fair ways of resolving issues which are reported to you, and you must make genuine recommendations.
I want you to focus on professional career growth. You have done well on conducive working environments. The expectations of the staff in that court from their own report as stakeholders is professional career growth. You are seated there as a judge. The staff expects some guidance from you or from that court.
Okay, thank you. Training is key.
Training,
relevant training, and making that giving equal opportunity to the staff.
Okay.
You know, to be trained and to develop themselves. And also genuinely supporting them when they want to advance in their careers by giving them appropriate recommendations, which sometimes are not forthcoming.
Okay. Thank you, Judge. Thank you,
Yes.
Professor.
Thank you, Commissioner Gishu. Thank you, Your Honor. Commissioner Koskei, it's your turn, please.
Thank you, Chair. Good morning, Judge.
Morning.
Yeah, I have two questions, very short ones. Following what Commissioner Mashari asked and the AG, and you did a lot of explanations, and I saw that you really read everything around Supreme Court. So I wanted to ask, what is, in your reading and as a judge, because you are an insider, you must have interacted with the Supreme Court. In your view, what is the significant challenge that the Supreme Court is facing currently? And as you are walking into that court, what are the possible solutions are you going to offer to sort out those challenges that you have identified now?
I think just like the judiciary as a whole, the public perception of us as a judiciary, and more so the apex court, is very, very important. And I think from what I read, a lot of negative things are said about the Supreme Court, and many of them may be just perceptions and not so it's very, because we serve the public, whether those perceptions are real or true. We must find a way of bridging that perception gap. And you do that by the way you portray yourselves as, even as judges.
What is this perception you're talking about?
That, for example, that the jurisprudence of the Supreme Court is below par. You know, you will find things being thrown like that inconsistently. You will find perceptions of corruptions which cuts across, and I think we have a duty to, as judges at every level, and more so at the Supreme Court, to come up with policies and with initiatives, especially in communication, having with the ways of first of all through our judgments, you know, as and especially in critical areas, as and when we are called upon, coming, and two, basically coming up the way we deal with our customers, the public when they come, you know, coming up with the service charters, which I know I think the Supreme Court has one, which making it easy to first of all to access the court and to understand it, because in terms of and that is mainly communicating to the people. The other day I talked about speaking to the people through radio, for example, and in Swahili to the people about what we do, what the court is about, and the Supreme Court judgments are very complex and cannot be easily understood. So how do we communicate? And sometimes now, as the communication unit, how does it explain those judgments to the Kenyan people? You know, or what we do? I think that is crucial.
Thank you, Judge. My second question is on your current court, employment and labor relations. You've been there for 9 years now?
I think this is the ninth one.
Ninth, yeah, and you are among the pioneers.
Yes, I was the first principal judge.
First principal judge. ELRC, has it met its objective in as far as perhaps stabilizing labor issues in this country, and has it somehow, brought in some confidence in investment and business? Because there is a lot of talk out there that you are very sure if an employee takes you to labor court, the employee will win, and the employer will be in trouble, and therefore it has made employers and by extension investors to be a bit jittery, to be apprehensive. To you as the first principal judge, how do you see the success of this court, and what do you think are possible suggestions that you can bring to improve the relationship between the court and the investors, so that this country can be a destination of choice in as far as investment is concerned?
Thank you very much for that question. Again, as I spoke a bit about that last time, that this court actually was not in existence in the judiciary. It was a small unit in the Ministry of Labor, so it started from scratch, and so we start from the statute which was passed, to the rules which we developed, to the service charter which we developed, to the working operational systems which we put in place, and the jurisprudence which we have developed since 2012 to date, I think, and the expansion in terms of going to the regions. Now we are, I think, as 7, and then we have 11 substations. Of course, we still have 12 judges. So there's that very big constraint in terms of going to the counties as is envisaged by the Constitution. But I would say that the jurisprudence of that court as together as developed by the judges and reviewed by the Court of Appeal, as to a large extent settled down on key issues, because the role of the Court of Appeal in bringing certainty to our jurisprudence is key, because when you have many judges and it's a new area, actually most of the areas of that court were new, and so initially it was difficult, but I think even the Court of Appeal has settled most of the key issues, so there is certainty. Then we started the court users committees, which are very effective actually in that court. All the stations have got very, very effective interactions with the public through the court users committees, which I put in place then. And I said we were the first court also to start inns of court, which are other courts until now don't have. So the Nairobi court has what we call inns of court, that is occasional interactions with the advocates who practice in that court, over a cup of tea, discussing different topics, and it's a very good way of interacting with the public. That is one of the things which I also started there. And the service charter very key, and also the open days, which we also started in line with the policy of the judiciary. It is working very well for that court. It will be interesting for PPMU to do a statistic of how many cases actually are for employees vis-a-vis those for the employers. A lot of times these perception, because usually interesting cases are those won by employees, and they are more reported than those lost. So there's also that. I've noted that, especially the newspapers, they pick more cases where employees have won their cases, and hardly ever report cases which have been lost. So that also contributes to the message which gets out there.
Thank you. My final, I really want to seek clarifications on, there's a question that Commissioner Machari asked, the aboriginal balance, and you really explained to the point of almost convincing us by saying that first of all you look at integrity, then you come to competence, and then suitability, which includes regional balance, issues of ethnicity and everything else, should be number 3. You know where we're coming from in Kenya, and Mutuetu syndrome is there, and it will be there for a long time, and we can't just sweep it under the carpet and say let us see the competences, because they will also say even our people are also competent. They have gone to school. We have also some that have integrity as anybody else. So why 3 from one corner? Why 10 from one village? That is the question, and it's a difficult thing because of the situation that we are. I was reading this morning, there are also other countries that are grappling with the same, but it is different because it is not tribalism, it is not ethnicity. In the areas it is about development, regional balance in development, because they are beyond this ethnic profiling like Kenya. Now, what do we do? In your view, what do we do? Because we have to, first of all, abide by the Constitution, that we have to look at it. Secondly, we have also to be fair to each and every community, to each and every region. Because if it means that you have to have these people evenly distributed for the stability and development of a country, then you have to do it. How do you think we need to do? Because focusing only on integrity and competence, we may not go far, because it is a problem that will take many years to sort out. In your view, what should we do?
I think the first the first thing, as I said, is to let Kenyans know how you have managed to deal with the issue of regional and ethnic balance in the judiciary as a whole, and not to try and deal with unit by unit. If those figures were there and understood, then people would understand why there has never been a person from Embu, for example, in the Court of Appeal, or there has never been a person from Embu like me in the Supreme Court. And they would understand why people from other communities are occupying leadership positions at different levels within the judiciary. And we would see whether we are well distributed in all the cadre, staff, magistracy, judges. We should be able to if you do that, you will have no pressure in filling up one unit. If it is clear that there is balance overall, then there should be no pressure in filling one unit. It's a matter of communication, and I think that needs to be done actually in how balanced are we as a judiciary in every organ of the judiciary. How balanced every unit, every superior court, how balanced are we in leadership and leadership including the administrative cadre. How balanced are we?
Well said. Thank you. Thank you, Judge. Thank you, Chair.
Thank you, Commissioner Koskei. Honorable Commissioner Olwende, is your chance, please.
Thank you, Chair. Judge, still on the same issue, I heard what you said concerning what we should give priority when it comes to balancing the issue of integrity, competence, judicial philosophy, and I agree with you on that. But there's an issue that there's a parallel that you drew that I felt may leave a wrong message, which I just want to clear before we proceed. You drew parallels with some principal judges of several courts, and you said that does that bother us? I remember you posed that question, I think it was to Commissioner Macharia. But I think it's important to also make the distinction, which is actually recognized at Article 73, which you referred to, that when it comes to elective positions, it's about free and fair elections. You really have very little room to maneuver any kind of balance. I just wanted us to agree on that, just to clear the air, because when it comes to principal judges, it's an elective position. Is that correct?
It's correct. I agree with you.
Thank you.
When it comes to elective positions, it's about numbers.
Yes.
Because, yes.
Yes, I think it was important to make that clarification.
Yes.
Thank you.
Yes.
Okay, now moving on to the question that I have. Section 24 of the Children's Act basically gives instances in which someone can acquire parental responsibility of a child. And in that section, basically, when a child is born to a man and a woman who are married, both of them have parental responsibility. If a child is born to a man and woman who are not married, but subsequently do marry, then again they both acquire parental responsibility over that child. If a child is born to a man and a woman who are not married, and they do not subsequently marry, parental responsibility basically attaches to the mother, and the father can only acquire parental responsibility in several instances that have been given in Section 25, basically applying to the court or entering into a parental responsibility agreement or acknowledging the child as is, or even maintaining the child. So that if a father chooses not to do those acts that will attach parental responsibility to him, then according to Section 24 of the Children's Act, parental responsibility would not attach to him, even though he may be or he is the father of the child. I just want to hear your views concerning that provision.
First of all, every parent has a responsibility to take care and maintain and ensure the welfare of a biological child, adopted child. So a question of a man who is not married to a mother not taking responsibility is, in my view, unlawful. And that is why we have many cases of maintenance and literally forcing fathers to maintain their children. So I think it's outright unlawful for a father to not maintain and support their child.
Thank you, Judge. Thank you, Judge. Would you say it's also unconstitutional? And if you say so, if you think so, maybe you can tell us why, and maybe feel free to cite any cases in support of that position.
First of all, in the Bill of Rights, we have specific articles which deal with the children. And basically, we have the responsibility by the state. We have responsibility but basically by the state, but I'm trying to recall whether there is an article directly dealing with the parental responsibility, but I think it is there too, that a parent is asked to is obliged to support and be responsible for the welfare of their child. I know this is family law, children's court issues which I've not interacted much with, but we read about every other day, and I think we have a constitutional mandate as parents. I mean, to take care of our children, and without going to specific cases, but I read about them every day as they come from the magistrate courts and the high court.
Yes, actually it is. Sorry, it is in Article 53. It's provided what you are saying about parents maintaining their children, and actually there's case law under which that section was declared unconstitutional. Okay, my next question arises out of the Judicial Service Code of Conduct. There's a provision there that says a judge shall disqualify himself or herself in any proceedings in which his or her impartiality might reasonably be questioned. Now, in what circumstances can the need to disqualify yourself be dispensed with?
First of all, if there is a conflict of interest with regard to either the party or the subject matter of the suit, if you have an interest in the subject matter of the suit, if you are related or you have a special relationship to a party, then first of all you have an obligation to disclose, and also to recuse yourself in a matter. This issue of there are issues of where your authority as a judge has been impugned publicly, for example, by a party, and as an officer you feel that whatever decision you make, they will never believe that it was free and fair, it was fair. So in those circumstances also you may recuse yourself. Usually it's the parties who move the court to recuse itself for various reasons, but the judge has got obligation of disclosure in certain circumstances, and the parties may feel that you don't have to recuse yourself given what you've told them, and you proceed with the hearing. Yeah, but I think in the situations of conflict of interest, you disclose, and then the parties may ask you to recuse yourself. Or where the parties feel for some reason you are biased in the way you have dealt with the matter, you may also consider whether that is or is not the case, and decline to recuse yourself, or depending on the facts, recuse yourself. Yeah.
Thank you, my lord. But what I'm asking is the instances when you can dispense with that requirement to recuse yourself or to disqualify yourself.
Dispense?
Yes.
Instances where you disclose to the parties your whatever case you feel may be between you and the case, and they feel that, and the parties say that they have no problem with that, then you may proceed to deal with the matter upon recording what has happened.
Any other instance?
Dispense with recusal. There are instances where there may be no other judge or officer to deal with the matter, and that there's need to deal with the matter expeditiously. And upon putting the issue forward, you make a ruling and dispense with that, and go ahead and hear the matter.
What about in the collegiate bench?
In a collegial bench, I think questions or issues which of interest must be disclosed, whether you are 5 or 10 or 1. If there's likelihood of bias or there's a likelihood of conflict, you must disclose that. You're not protected by the group. That is personal to the individual judge. Disclosure and recusal for good reason. So you're not shielded by the college. I think the responsibility still is personal, is the same.
Whose responsibility in that scenario is it to decide whether or not you should recuse yourself?
Ordinarily you have the presiding judge, but if an application for recusal is made, I believe the bench should retreat and discuss that in chambers. And it's at the end of the day, it's the responsibility of the individual officer. It's not for the presiding judge to decide that you recuse yourself. No, it is you to, as a judge or a magistrate, or to take that responsibility. But it should be done in confidence and in decorum, first of all, and then decision is communicated.
Very well. Moving on to the next question that I have. Please describe a workplace situation that tested the limits of your patience, if you've had that experience, and what you did, and now in hindsight, whether there's anything you think you could have done better.
The one which comes immediately to my mind is initially the teacher's case, when children were at home for over two months because of a teacher's strike. And when the parties came before me, being the arbitrator I am, being the mediator I am, by the way trained, I engaged the parties and we entered into conciliation proceedings, which resulted to the teachers immediately going back to school, by the way, and schools reopening immediately. And before even the case started. In hindsight, having engaged in that conciliation process, I should have then given the matter to another judge to hear it, in hindsight. But in the heat of the moment and everything being done with the agreement of the parties, that did not immediately occur to me, and I proceeded with the case. So that one, I told Commissioner Njeru the other day, in other jurisdictions, courts are allowed to engage the parties on conciliation, mediation. If it is successful, well and good. If it is not successful, then the right thing to do is to give the case to the next judge, so that, that one, in hindsight, I said, oh, how did I miss that?
Thank you very much, Judge. I wish you well. Thank you, Chair.
Thank you.
Thank you very much, Commissioner Orwade. Your Honor, this brings us to the end of this interview. And on behalf of my fellow commissioners, we want to thank you for coming. And in addition to the work we are doing in terms of looking for the judge of the Supreme Court, we have learned a lot through these discussions, and we want to thank you for that. So I don't know whether you have anything to tell us before you go, Your Honor.
Just to thank you very much. Actually, this is been a very rich, enriching experience. I think the Kenyan people have learnt a lot from this. This commission, I'm sure, has learnt a lot from the participants here, and I'm sure some of the things which have come out of this process will be implemented. Maybe will be work in progress for this commission. So I want to thank you and for the manner in which you've conducted these interviews from the beginning, and it's been very amiable, and I really appreciate very much, and I thank each one of you individually and collectively. This is to the glory of the country and to up there.
Thank you, Your Honor, for those comments. Thank you.